Can you hear me? We are live. Can you hear me? Okay, come on, invite your friends, your enemies, your family members. Invite everyone that needs to be here. We are live, we are live. If you're here, let me see your fire emojis. Okay, I can see Odor. Nancy is here. So we start very soon. Wait for others a little bit and then we start. start now. So I'm going to share my screen with you. Let me share my screen with you. Okay, I hope you can see my screen. Wait, can you see my screen? 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 Oh, why? Okay, let me check it again. I'm trying to share my screen. Why is the screen not coming up? Let me figure this thing out. Okay, I think it's showing now. Okay. Okay, fantastic. I can see the screen now. Okay, fantastic. Okay, good afternoon, everyone. Good evening, depending on where you are joining us from. My name is Dr. Felix, and I am a PhD, and I am also an immigration consultant. Today, we'll be looking at how to get your EB1 or EB2 approved in 2026 despite the current immigration climate. All over the world, we know what is happening as far as immigration is concerned. Rules have become stricter, more tougher, and then it seems as if it has become more difficult to get your EB1 or your EB2 approved. So we want to demystify these two categories here today. And at the end of the day, I will give you an opportunity to ask me questions. And once in a while, I also have my phone here. I'll be checking the chat in case anyone throws in any question there. Now, there are four currencies in life, and the acronym I have for them is MEAT. That is money, energy, attention, and time. Whenever you are exchanging with people, you either pay one of these currencies, money, or your energy, or your attention, or your time. So at the end of this webinar, I'm sure that you'll have gotten value for your energy, your attention, and the time that you are going to spend with me listening and watching this webinar. So, who am I? I'm Dr. Felix, and I have a PhD in Germanic Studies from the University of Illinois, Urbana-Champaign. I am also the principal immigration consultant at IFX Immigration Partners. Few years ago, I self-petitioned for my EB2 without an attorney, and I was able to get an approval without a request for evidence or RFE. Until date, I have helped more than 75 people with their employment-based cases with a 92% approval rate. So I specialize in EB1, EB2, O1 for everyone and for Nigerian professionals as well. So what are we going to cover today? Today I'm going to tell you about my little story, and then we are going to break down a NOID case that I recently got approved. NOID is Notice of Intention to Deny. That is when you submit your application to USCIS. If the officer reads your application and he or she is not convinced, then they can issue a notice of intention to deny. Maybe if you have met the three criteria as far as EB1 is concerned, and in the final merit determination, the officer sees or feels or thinks that you are not among the people who have risen to the very top of their field, they might issue you a NOID. Then we'll look at why strong professionals still get denied and how to position your petition, how to position yourself for approval. We also look at the legal frameworks for EB2 NIW and for EB1 and how to argue for both correctly. Additionally, we'll look at the evidence that wins, that is citations, salary benchmarks, letters, recommendation letters, media, the evidence hierarchy that matters. And at the end of the webinar, I will introduce you to the 30-day challenge, EB1 and EB2 challenge that is starting very soon. That is, you will be able to write your petition in 30 days. Okay, so as I said, I am Dr. Felix, and I came into the US to come and do my PhD some years ago in Germanic studies, and I'm also a published author, and I've published some articles and some books. So a few years ago, I heard about EB1 and EB2 and decided to self-petition. That is, I read a lot of petitions, I read a lot of recommendation letters, and I attended webinars just like you are attending now. Because I did not have 5,000 or 10,000 to spend or to give an attorney, I decided to put in the work writing the petition myself, even though it was a very lengthy process. It took me about 6 to 8 months to write my petition. And then because of the field in which I found myself, most attorneys actually rejected my case. Why? Because at that point in time, I did not have a citation, and attorneys tend to reject cases that are from the humanities because of this idea that people or cases in the sciences are easier to handle for attorneys. So I try to understand and study that answer. I was able to understand it, and then I wrote my petition, and to God be the glory, it was approved without a RFE, without getting any request for evidence from USCIS. And since then, I have helped several professionals, several international students get their green card through EB1 and EB2 NIW. And recently, I was able to get a NOID overturned. Even if a NOID is one of the most difficult things to get reversed or overturned by USCIS. Even attorneys failed. But by God's grace, I was able to get that case reversed and that case approved, that NIW reversed and that case approved. Now, let's talk about the 2026 immigration climate, what you are up against. You need to understand that the environment is tougher. The standard has not changed, but your strategy has to be airtight. Why? Because there is increased USCIS scrutiny. Officers are applying higher scrutiny to employment-based petitions. Evidence that passed 2 or 3 years ago is being questioned today. For example, 2 or 3 years ago, if you had a citation, you could actually say that I have XYZ number of citation, and USCIS will believe you and they will say that yes, you have impacted your field. Then it means that you are well positioned to advance your proposed endeavor. But today, USCIS will require that you submit letters or you submit evidence apart from your citation that your work has truly been used. Another thing that is happening right now is there is a rise in RFEs and NIW. That is, there's a rising RFE and NIW rate. Requests for evidence and NIW are being issued at higher rates today, even for well-credentialed professionals. So procedural compliance is critical. You need to understand what you are doing. You cannot afford to gamble this time around. You cannot afford to submit a weak petition. You cannot afford to have a weak profile and then gamble and begin to hope for the best. Now, as far as EB1 is concerned, there is a tighter merit standards. Final merit determination are being applied more aggressively today. That is, it means that meeting 3 criteria is no longer enough. The totality of evidence, as far as EB1 is concerned, must be overwhelming. It must show that you are really among the small percentage of people who have risen to the top of their field. Also, there is a longer processing time today. Processing timeline have extended significantly, especially for people that are doing regular filing. A week filing that triggers an RFE can add 6 to 12 months to your timeline, especially if you are using regular filing, if you're not doing premium processing, or if the RFE is not well handled, it might end up in a denial. So the professionals or the international students who win in this climate are the ones who prepare like the standard is higher, because the standard is actually higher today. So there is a higher level of scrutiny of your certificate, a higher level of scrutiny of your achievement, a higher level of scrutiny of your pieces of evidence. Now, let's talk about this real case study that is beating a NIW for an Amazon manager. So the name I'm going to use for this person is Maya. That is not the real name of the client. So for the sake of confidentiality, I'm calling this particular client Maya. And this particular client is a capacity planning manager at Amazon. And mind you, before they worked with me, they worked with IFX Immigration Partners, Amazon had engaged their lawyers, and then they filed for EB2 for this particular client, and the petition got a RFE. After the Amazon lawyers responded to the RFE, the petition was denied. So this particular client came to us, and then we looked at their profile and felt that they could go for EB1 because of their achievement. So we filed in EB1 and we claimed 6 criteria. The first criteria was commanding a high salary, that they commanded a high salary. The second one was scholarly articles. The third one was review, that is judging the work of others. The fourth one was leading and critical roles. The fifth one was media publications, and the sixth one was awards. So when USCIS looked at the petition and they adjudicated the petition, and they felt they considered 4 criteria out of 6 criteria. So the criteria that were considered were media publication. USCIS just accepted the one publication out of 6. They considered the judging the work of others. They also considered the award criteria, and then they also considered the scholarly article criteria. So we had 2 criteria left. That is the leading and critical roles, and then the salary criterion. So what was USCIS saying as far as the salary is concerned? Remember that I told you that this person is a capacity planning manager and they have a degree in industrial engineering. So the area of extraordinary ability that we claimed was industrial engineering. That is extraordinary ability in industrial engineering, specifically logistics and supply chain. So the adjudicating officer said that we compare the salary against the wrong field. Excuse me, I need to drink some water. So the adjudicating officer said that we compared the salary against the wrong field. And then they also accepted 1 media out of 6 that we submitted. We also submitted editorial positions that were not mentioned in the NOID. And at the final merit determination, USCIS stated that the piece of evidence were insufficient to show that Meyer, that is the client, was at the top of their field. So what was the strategy that I used? I attacked the Kazarian step conflation, and I also proved that capacity planning manager is a subfield of industrial engineering. And I looked for articles online that show that capacity planning manager is actually a subfield of industrial engineering. And as far as the salary was concerned, what I did is that I show USCIS that I used the right field, because capacity planning manager, to be a capacity planning manager, you need most often than not a degree in industrial engineering. People that have a degree in industrial engineering could be capacity planning manager. I also looked at job ads where Amazon was advertising for capacity planning manager positions and requiring that the applicants have a degree in industrial engineering. And then I also went and looked for data for capacity planning manager, the salaries of capacity planning managers. So I showed USCIS that even when it comes to industrial engineering, compared to other industrial engineers, Maya was earning in the 90th percentile of earners. Now, even if I were to agree with you that you want me to compare Maya with capacity planning managers, she will still be among the 90th percentile of earners in her field. So that was how I was able to work around USCIS contradiction or USCIS opposition. Now, when it came to leading and critical role, USCIS actually failed to talk about that. And then I resubmitted part of the document that I submitted in the original petition, and I got new letters that talk about the significant roles that Maya played at our companies and the impact of our roles in those companies. So I got new HR consultant letters to show that our salary is among the top percentile of earners in our field. And because USCIS failed to mention the editorial positions, I got letters from the journal editors where she held editorial positions to state that our editorial roles and our editorial duties surpassed those of other associate editors. And so the weapons that I used were the BLS 98th percentile benchmark. I also use a dual comparison, that is industrial engineering for salaries for industrial engineers and capacity managers. I also pointed out the Kazarian procedural error that USCIS made because they added some requirements in the final merit, saying, for example, that we are not shown that Maya has judged a bigger number of, or reviewed a bigger number of papers, which was USCIS actually adding extra requirement, which was forbidden by the law. I also got independent editorial letters, and I also showed how the awards that she won at Amazon and at FedEx, where she worked before, were among the top awards in the field and in our company. So that really helped the case, and we were able to win the case. To God be the glory. So now let's talk about EB1, EB1A. How is it really decided? I know if you want to do EB1 or EB2, let me see you type that in the chat. I'm looking at the chat right now. Let me see you type that in the chat. What are you interested in? Are you interested in EB1 or EB2? Okay, EB2, I see. EB2. Oh, Esther is saying EB2. Okay, so let's talk about EB1. Now, when you are applying for EB1, you need to meet at least 3 criteria out of 10 criteria. Now, the 3 criteria that you need to meet, this is the floor, not the finish line. There are 2 steps in EB1. The first step is the evidentiary threshold, that is meeting 3 out of 10 criteria. The second step is the final merit determination. Now, what are those 10 criteria that you need to meet in EB1, in the first step of EB1? Now, the first one is awards, that is the receipt of lesser nationally or internationally recognized awards in your field. The second one is media publication or media coverage about you and your work in the field. The third one is making original contributions of major significance. The fourth criterion is leading and critical roles, performing in a leading and critical role for organizations with a distinguished reputation. The fifth one is membership in organizations that require outstanding achievement of their members. The sixth one is published articles or scholarly articles, publishing scholarly articles. The seventh one is judging the work of others in your field, in the field for which classification is required. The ninth one is high salary, commanding a high salary in relation to others in your field. And the 10th one is artistic exhibitions or performances. Artistic exhibitions or performances. So if you go to USCIS website, you will be able to see all these criteria on USCIS website. So when it comes to EB1, you need to meet at least 3 out of these 10 criteria. You need to meet at least 3 out of these 10 criteria. Now, when you finish meeting 3 out of these 10 criteria, it means that you have passed the first step. Then USCIS will now perform the second analysis. Now, in the second analysis, the second level of analysis, that is the final merit determination, the real question is, looking at all evidence in totality, does this person truly rise to the level of one of that small percentage who have risen to the very top of their field? Remember, EB1 is about what you have done. EB2 is about what you will do. EB1 is about what you have done, that is your achievement. EB2 is about what you will do. EB1 is about what you have done. EB2 is about what you will do. Now, once you pass step 1, you now get to step 2, where USCIS is asking that, does this person have sustained national or international acclaim? Sustained means continuous, something that has happened over a period of time, at least 3 years. Now, acclaim means recognition. Have your achievements been recognized in your field over a period of time? Now, once you pass that first step in the second level of analysis, USCIS says that, okay, now if this person has sustained acclaim, national or international acclaim, over a period of time, now do these achievements actually show that this person is at the very top of the field? And that is where many cases are lost. That is where many EB1 cases are lost. Now is not the time to submit a borderline case. Now is the time to submit an overwhelming case, a case that has overwhelming evidence. There is a level, or there is a way that you will write your petition that it will make it very difficult for the adjudicating officer to deny your petition. Why? Because the evidence is overwhelming. And that is what you want to achieve as a self-petitioner or as someone who works with a lawyer or with a consultant. So this is the error that we caught in Maya's case. We called it that out and we won the case. Why? Because when we looked at all the evidences that USCIS discounted and failed to mention in the NOID, we brought those evidence forward, like the editorial positions. We made a case that, okay, for you to be an editor in a journal, an international journal, it means that you are a gatekeeper. It is not for average professionals. It's not for people who are just starting their career. It's for people who have made impact and whose authority, whose expertise has been recognized in the field. For example, as far as salary is concerned, we made a case that, okay, Amazon will not pay an extraordinary salary to someone who is average, who is an ordinary professional. When it comes to award, we also made a case that people who are ordinary in their companies or in their field do not receive awards. So that is how to build your case in such a way that when you get to the final merit, the officer, it is already glaring to the officer that this person is truly at the top of their field. Now, let's talk about EB2. EB2. Let's talk about EB2. We looked at EB1. Now, let's talk about EB2. Now, for you to understand EB2, there are 3 prongs in EB2. That is, the first prong is that your work or your proposed endeavor needs to have substantial merit and national importance. The second prong is, in the second prong, you need to show that you are well positioned to advance your proposed endeavor. And in the third prong, you need to show that waiving the labor certification will be more beneficial to the United States than for them to want you to go through the labor certification. So when it comes to EB2, there are two kinds of EB2, or for lack of a better word, there are two parts rather in EB2. There is the advanced degree part and there is the exceptional ability part. There is the advanced degree part and there is the exceptional ability part. What does that mean? It means that if you think that your profile is not strong enough to go for EB1, EB1 is for people who have risen to the very top of their field. Remember, people who have risen to the very top of their field. Some people call EB1 the Einstein visa. The Einstein visa. Of course, not everyone who gets EB1 is at the level of Albert Einstein, but it is a very restrictive visa category. Now, EB2, I was talking about EB2. There are two parts to EB2. There is the advanced degree part and there is the exceptional ability part. But I will focus more on the advanced degree part. The advanced degree part, it means that if you have a master's degree or you have a PhD or you have a bachelor's degree plus 5 years of experience in a particular field, you can apply for EB2. Let me take it again. If you have a master's degree or a PhD or you have a bachelor's degree plus 5 years of experience in a particular field, you can apply for EB2. Now, there is another part, which is the exceptional ability part. In the exceptional ability part, you mean even if you don't have a bachelor's degree, you have an associate degree, or you have any kind of certificate, you could apply. That is, there are 6 requirements that USCIS looked at. And out of those 6 requirements, you need to meet at least 3. And some of them, I'm just going to name some of them. One of them is that you need to have membership in an association. Another requirement is that your contributions must have been recognized in your field. Another requirement is that you need to have commanded a high salary in relations to other people in your field. Another requirement is that you need to have a certificate to practice the particular profession that you are practicing. It might be an OND, it might be an associate degree, and so on and so forth. Or you could get a letter that shows that you have spent at least 10 years in that particular field. So you do not need to meet all these requirements. You only need to meet 3 requirements. That is if you are towing the exceptional ability pathway. Remember, I told you as far as EB2 is concerned, there are 2 pathways. There is the advanced degree pathway. There is the exceptional ability pathway. The most straightforward pathway is the advanced degree pathway. That is, you have a master's or you have a PhD or you have a bachelor's degree plus 5 years of experience in the field. Then once your eligibility is ascertained, then we move to the next level. You need to have a proposed endeavor. A proposed endeavor is a specific activity that you need to carry out, that you want to carry out in the United States. That is, it could be that you may want to create a language school, or you may want to do research relating to cancer or relating to renewable energy, or you want to do research relating to drug abuse, or you want to come up with a solution that will reduce the use of fentanyl in the United States. But you need to have something that you want to do in the United States that will benefit the country. So that is a proposed endeavor. So in the first prong, you are going to show that your proposed endeavor has substantial merit and national importance. Your proposed endeavor must have both substantial merit and national importance. So these are 2 different things. Merit means intrinsic value. National importance means that the impact of your proposed endeavor will go beyond your local or single employer. So you need to show field-wide implications, societal welfare improvement, government identified national priorities. That is, you need to show how your proposed endeavor aligns with government identified national priorities. You also need to show that your proposed endeavor can create jobs for Americans in an economically deprived area, for example. That is prong one. So once you pass prong one, then the officer goes to prong two. In prong two, that is where you demonstrate that you are well positioned to advance your proposed endeavor, or that you are well positioned to advance your work. And how do you do that? There are four things that USCIS looks at. The first one is that you need to demonstrate that you have the degrees and the credentials to do that particular endeavor, and that you have a record of success in similar or related endeavor. What that means is that you have done something like that in the past, or something related to what you want to do in the US in the past, and you succeeded. The second thing you need to show is that you have made significant progress relating to your proposed endeavor. The third thing you need to show in this prong is that there are parties, relevant parties, that are interested in your proposed endeavor. And the fourth thing is for you to show that you have a plan for future activities. So you cannot just say that, okay, I have a degree in German, I have a degree in French, I have a degree in engineering, then I am well positioned. No, that it doesn't work like that. You need to show outcomes. If you have publications, good. If you have citations, good. If you have grants, if you have built program, you have patent, you have gotten recognition from your field, the more the better, the more the stronger your case becomes. And then the third prong is how your work will benefit the US in such a way that it becomes a matter of national interest for the US to waive the labor certification. You see, when you go through an employer and you want to get your green card, your employer needs to file for what is called a perm labor certification. But going through EB2 and NIW, you are trying to tell the adjudicator that what I'm doing is so important to the United States that I don't need to go through that perm certification. I don't need to go through it. Why? Because what I am doing is urgent, that my work serves national interest, and the standard process of the perm will create unnecessary barriers to that national benefit. Okay. Now let's talk about why strong professionals still get denied. The first reason is, now I'm talking for EB1 and EB2 now. I've seen people who have strong credentials that still got denied. Last week, I was talking to someone who reached out to me and they said that they wrote their EB1 and then they got denied. So it happens sometimes that people with strong qualifications get denied. And then what are the reasons? Number one of the reasons is the checkbox mentality. That is, meeting three criteria barely is not extraordinary. Officers evaluate totality. You need to overwhelm the officer, not just qualify. People think the mistake that people make sometimes is that, okay, EB1 has 10 criteria. Okay, I think I can meet 3 or 4 out of these 10 criteria, but that is this first step of the analysis. There is a second level, a second layer of analysis where most petitions are denied. That is the final merit determination. The second reason is because of generic evidence, vague letters, and unprovable claims, which signal weakness. Specific technical contextualized evidence is what wins your case. Whatever claim that you are making as far as EB1 or EB2 is concerned, there should be an evidence. There should be an evidence. The standard of adjudication in EB1 and EB2 is the preponderance of evidence. The preponderance of evidence. What that means in law is that 51%, that this particular evidence is 51% more likely to be true than not. Or this person is 51% more likely to be extraordinary than not. This person is 51% more likely to serve the national interest than not. The third reason is no petition brief. That is people submitting documents without narrative, which are a pile of paper. Officers won't connect the dot. You must do it explicitly, and that is what you do by writing a cover letter or a petition letter. So one of the mistakes that people make is that they just write the petition letter like an academic document. This is not an academic document. This is a legal document. This is a legal case. So you need to build your case like you are in court, the court of law. The fourth reason why strong professionals seek get denied is because of the wrong classification. That is filing for EB1A when your profile fits NIW or EB2, or NIW when you qualify for EB1. So that invites the wrong scrutiny level. So you need to, if you need to get a consultation, get a consultation. Okay, am I qualified for EB1 or am I qualified for EB2? There are people that go for EB2 who don't have any business going for EB2. They are supposed to go for EB1 by the virtue of their qualifications and by the virtue of their achievements. Remember, EB1 is about what you have done, your extraordinary ability, while EB2 is about what you will do, your proposed endeavor. The fifth reason is poor salary evidence. Submitting raw salary without benchmarks, expert analysis, or PPP context leaves room for rejection. The sixth one is overlooked evidence. You see, in Maya's case, the case that we were able to win, 5 of 6 media and all editorial positions were ignored. Officers miss things sometimes. So your brief or your letter, your cover letter must surface everything. The seventh reason why strong professionals still get denied is because of filing too early. You see, a weak case filed under pressure costs time, money, and possibly the case. 6 more months of evidence building can change the outcome of your case. So if you see that you have a weak case, there is no need rushing. Try to build your case. And the eighth reason is no specialist strategy. EB1A and NIW require legal strategy, not form completion. General practitioners miss critical nuances every time. If you understand EB1 clearly or EB2 clearly and you feel that you can write or self-petition by yourself, go ahead and do it, but ensure that you understand it very well. If you don't, employ the service of a consultant or a lawyer. Now, how to align your evidence to USCIS criteria? How to align your evidence to USCIS criteria? It is not enough to have the evidence. You must present it in the language USCIS is looking for. So let's look at EB1, for example. What actually proves it? When you talk about high salary, so the benchmark that you are looking at is 98 plus percentile. That is, if your earning is among the 90th percentile, you have a very good chance of getting that criterion approved. So you need a role specific comparison. And then if you can get HR letters to support the fact that you are earning extraordinarily or that your salary is significantly above others and why it is above others, then it helps your case. Now let's talk about original contributions. You can use Clarivate top 1 to 10% citation rank. You can get independent letters describing the specific adoption of your work and independent letters that shows why your original contribution is of major significance in your field, and letters that actually show that your inventions or your contributions are actually original, and they are also of major significance in your field, and why. What is their impact in the field? Now, let's talking about judging activities or peer review. You can get invitation letters or invitation emails and thank you emails. If you judge for journal, you can look at the journal prestige data. You can submit proof of review, proofs that show that you actually did the work, like assessment report, for example. You can also submit the selection criteria for judges or people that judge the work of others. Now, for scholarly article, you can submit the journal impact factor percentile. You can submit your citation count. You can submit independent letters of authors that cited your work. For leading and critical role, you need to submit the organizational chart, the scope of your responsibility, and the impact of your work, and how your work led or contributed significantly to the success of the company's activities. For media, you need to show the outlet circulation and reach, editorial standards, why your features, not generic press release. And that is where people make mistakes sometimes. Sometimes people actually go ahead and pay people to do some media outlet to do press releases for them. And while they think that that might help their case, most time USCIS can detect these kind of things. And once they see that this thing was paid for, it actually reduces the credibility of your case. Awards, as far as awards are concerned, you need to show the selection rates, the award criteria, the significance in the field, and everything needs to be documented. Now, let's talk about how to ethically build your EB1 or EB2 profile. How to ethically build your EB1 and EB2 profile. First and foremost, you need to publish strategically. Target the top 10% journal by JCR impact factor. So pick emerging problems in your field and then write about them. As far as EB1 is concerned, or as far as EB2 is concerned, quality matters over volume. One paper in a very top journal in your field is worth more than 5 papers in a predatory journal. So you need to publish strategically. You need to be strategic in your publications. Don't just publish for publishing's sake. Now, let's talk about judge and review. You can volunteer for peer review activities. You can serve on editorial boards, apply to judge competitions. Sometimes if you see journals reaching out to you to serve as a peer reviewer, do not reject it. Do it. By doing so, you are building your profile. You are building your profile strategically. You are building your profile intentionally. Request invitation letters documenting selection criteria, because one of the undoing of applicants sometimes is that they do things and then they do not have evidence to back up whatever they have done. From today, whatever you do, ensure that you get evidence that shows that you did it. You are invited to speak at the conference. Get a letter that shows that you're invited. Get a thank you letter that shows that, okay, people actually valued your presentation. Whatever you do from today, get an evidence to back up whatever you do. Accumulate recognition, apply for competitive awards, industry honors, professional society recognitions, document selection rates and criteria. There are some organizations that require outstanding achievement. If you read the selection criteria and you feel that you meet those criteria, you can apply and get those awards. By doing all of this, you are actually building your case, your EB1 case, your EB2 case. Then build independent letters, cultivate relationships with researchers outside your institutions. These become your most powerful citation letters. For example, there are two types of recommendation letters. There is the dependent recommendation letter and there is the independent recommendation letter. The dependent recommendation letter is a letter from maybe your supervisor or people that are in your network, your collaborators, people that know you. But USCIS values independent recommendation letters more because they feel that it is less biased. They feel that those people will be more objective. Then track your citation data. Use Clarivate Web of Science. Know your H index, percentile rankings, and which papers are in the top 1%, 5%, 10%. So there is this thing called essential science indicators. You can type it after this webinar that shows the percentile of the citations. It is also called Clarivate Analytics. So you can use it to know where your citation count stand, whether it is among the 1% most cited papers, your paper is among the most 1% or 5% or 10% most cited papers in a particular year. So all of this actually builds your profile. Document everything now. Save every invitation, award letter, salary document, organizational chart, media mention, and performance review. Build your evidence. Build your evidence file today. Profile building is not gaming the system. It is becoming genuinely extraordinary and then documenting it so USCIS can see it. You see, whenever you file for EB1 or EB2, the burden of proof and persuasion is on you, the petitioner or the applicant. That is, you have to produce the pieces of evidence and you have to persuade USCIS. So the burden of proof is on the applicant. How to use citations to prove top of the field. Citations are not a score, they are an argument if you build them correctly. For example, if you use that Clarivate Analytics or you use the essential science indicators I told you, and you have citations, you'll be able to see citations for different fields, citation percentiles for different fields. Then you'll be able to know whether your citations are among the 1%, top 1% globally, top 5% globally, top 10% globally. So when your citation is among the top 1% globally, it shows global elite. That is, you are one in a hundred. That is one in 100 papers produced in your field that year. So Clarivate Essential Science Indicator confirms this ranking independently, and USCIS need, or they have to accept it. Why? Because it is an independent indicator. So if your paper is among the 1% most cited paper for a particular year in your field, it is a strong evidence. It is, if it is in the top 5%, it shows high that your paper was highly impactful. It is a strong percentile showing. Now, combined with journal JCR ranking, it builds a compelling two-layer bibliometric argument. So top 10% is also an upper decile of global output. It is meaningful when combined with letter evidence, which shows your work circulates widely in the field. So now, apart from citations, it is also a good idea to get recommendation letters from people who cited your work. So you could get 2, 3, 4, 5, 6 letters from independent researchers who cited your top ranked papers. Each letter explain why they cited you, how they used your work, what it enabled them to do. So when you send an email to international researchers or citers, what it shows is that it shows international acclaim. And this converts a statistic into a story. EB1 is about you telling your story, about a story about your achievement. It's about you telling a compelling story around your achievement. Now you have the knowledge. The question is, what are you going to do with it? Leave this webinar with good information and no structure? Try to figure it out alone over the next 6 to 12 months? Pay $10,000 plus to an attorney who may not know your field? Or you can also join the 30-day challenge and build your petition with expert guidance. So for the next 30 days, I'm gathering a few people to teach you everything I know about EB1 and EB2. And at the end of 30 days, you'll be able to write your petition and submit it to USCIS. So what are you going to get? You'll be able to build, you'll be able to structure, you'll be able to finish, and you'll be able to submit your petition without paying 10,000 plus in attorney's fees. So in week 1, we'll work on positioning, we'll engineer your field, define your proposed endeavor, and lock your case team. In week 2, we'll work on criteria strategy, map your achievement to EB2 or EB1 legal standards flawlessly. In week 3, you will build your full petition narrative using our proven structure. In week 4, we'll work on strengthening weak areas, refine, and prepare for final submission. So what do you walk away with? A complete EB2 or EB1 petition draft, structured exhibit plan, clear submission roadmap, mapped evidence strategy, and one professional review. That means that I will personally review your petition before you submit it, and you'll be guided on how to fill USCIS forms. So when do we start? On March 15. This is the founders cohort, and it is just $697. $697. Now, is the 30 days challenge right for you? This is for you if you're an international student preparing to self-petition, if you're a professional with strong achievement but no clear structure, if you're a researcher, you're a PhD candidate ready to file, if you're a high achiever who wants to execute without overpaying. It is for anyone who has received an RFE or a NOID and needs a strategy. It is for people who want to understand the process, not just sign forms. So this is not for you if you are looking for shortcuts or magic bullets. If you want guaranteed approvals without doing the work, if you are unwilling to invest 3 to 4 hour focus hours per week, this is not for you. You don't need to sign up. If you expect someone else to build your case for you, this is not for you. You don't need more information, you need structure. Build structure, finish, and submit. So, what is our track record behind this challenge? These are not hypotheticals, these are cases were built and won. 75 plus cases filed, 92% approval rate, one NOID reversed. So here you have it all. We are ready to help you for $697. This is just for a select few. And once the spots are filled, you will have to wait for the next challenge. So now you can apply. You can apply for our founders cohort. Payment plan is also available. You can send an email to admin@iofx.com. Please, if you have not yet subscribed to this YouTube channel, next week I'm going to have another webinar on another topic. Please go ahead and subscribe to this channel right now. Go ahead and subscribe to the channel. Okay, I'm ready to take your questions now. I am ready to take your questions. So if you want to apply, so here is the link to apply. Which one is easy to get? None is easy to get. None is easy to get. It depends on your profile. If you have a very strong profile or achievement, I would advise that you go for EB1. But you need a consultation. You need to consult with us so that we know which one you need to go for. Any other questions? So if you want to apply for the Founders Code, the link to apply is in the chat. Just check the chat for the link. So this is for EB1 and EB2. Thank you very much for joining this webinar. And next week, I'm also going to talk about another topic. So if you are yet to subscribe to this YouTube channel, we're always talking about immigration updates, how to get your EB1 or EB2 approved, and how to move to the United States or how to succeed in the United States as an immigrant. Please subscribe to the channel and share it with your friends and family. Thank you very much for joining. I'm ready to take the last question if you have any before I log off. I'm looking at it. the chat now. There's no question. Okay, good. So I will see you next week. Thanks, Felix, for this one now. You didn't mention you applied for it. Oh, Global Knowledge Partnership. No, I did not apply for EB1 later. I just applied for EB2 and then got my green card through EB2. I did not need to apply for EB1 later. So, but I've helped several people apply for EB1 because by the virtue of applying for EB2, I was able to also study the structure of EB1 and I understood it. And I've helped countless people apply for EB1 and I was able to get them approved. Okay, thank you guys. And I will see you next week. Bye-bye. If you have any question, feel free to reach out to us at admin@iofx.com. Okay, I will see you some other time. Is the founders code for people who want to submit the application or people that would like to build their case. Okay, it's for both people too. People that want to build their case can also join. People that want to also submit their application very soon can also join. Does your volunteering work in the US help your case? Yes, it does. Yes, it does. It does. It depends on what you have done. Then when we see or we know what you have done, then we'll be able to position it. That is, if what you have done is related to your proposed endeavor, then it can be useful. But if it's not related to what you are proposing to do, then it will just be a waste of space in your petition. So if it is related to what you have done or what you intend to do, that is your proposed endeavor, then it can help your case. But if it is not related to it, then it might just be a waste of space. Can my volunteering job from the UK work? Yes, it can. It can help your case depending on what you propose to do. If, for example, let's say that you are doing research on drug abuse, and then your volunteering work is related to helping people or helping people that are struggling with drug abuse, it can, of course, help you. But if there is no correlation, there is no way to actually connect your volunteering work with your proposed endeavor, then it becomes difficult to actually use it in your petition. Again, it also depends on whether you are applying for EB1 or EB2 as well. So next week, I will build an EB1 case or an EB2 case in front of you. I'll write it. I'll write an EB1 case or an EB2 case. So I will come with some fictional profiles and then we'll build EB1 cases or EB2 cases together. Okay, so I will see you next week. Any other question? Does EB2 have criteria just like EB1. Okay, BC flash. EB, so EB2 does not have criteria. EB2 have prongs. So we have three prongs in EB1, EB2. So we have the first prong where you need to show that your work has substantial merit and national importance. And we have the second prong where you need to show that you are well positioned to advance your proposed endeavor. And in the third prong, you need to show that it will be in the United States best interest to waive the labor certification. But EB1 has 10 criteria, and you need to meet at least 3 out of those 10 criteria. Now, meeting 3 out of those 10 criteria is not the end point, that is the start. It's just like a football match where the team draws, maybe they play 2-2, and then they go to extra time. So once you meet the 3 criteria and USCIS accept those 3 criteria, then they go to the second layer of analysis, the second step of analysis, and that is the final merit determination. So when you get to the final merit determination, that is where most cases are lost. Most cases are lost at the final merit determination, because I've seen several people who actually met 3, 4, 5 criteria, and then they lost the case at the final merit determination because USCIS said that they did not prove that the they were amongst the few people who have truly risen to the very top of the field. So remember, and I see people I see people pressure me a lot about this. They say, oh, and Dr. Felix, I think I can meet 3 criteria. I have scholarly articles, I have I have scholarly articles, I have awards, I have media publications, I've judged the work of others. Now let me give you a practical case now. I've had people who met me who have 2 articles, scholarly articles, who have judged the work of 3 people in 1 year, and then who have 2 media publications. And then you want to submit that kind of case to USCIS to say that you are extraordinary. How? How are you extraordinary? First and foremost, those achievements were not sustained, did not happen over a period of time. Number one. Number two, USCIS will ask you how publishing 1 or 2 articles in 1 year, how does that translate to sustained national or international acclaim? How does that show that you are among the few people who have truly risen to the very top of your field? How does that show that? So that is it. Okay, any other question? Okay, thank you guys. So I will see you next week.